Hello viewers, as promised I am back. In the last discussion we were taken up a discussion on negotiation and mediation, and today in the continuation of informal access to justice through these ADR methods, I am going to take up discussion on conciliation and arbitration. As a habit, I would be referring to yesterday's lecture quite often during today's discussion, and I hope you would be able to relate to those discussions. So, before I take up the today's discussion on conciliation and arbitration as a method for informal approach to justice, let me discuss the scheme of the study. So, as I am taking up two concepts, conciliation and arbitration, I will be taking up a discussion on definition, history, historical development. These I would be restricting myself to conciliation, and along with the conciliation I would be making a reference to arbitration. But when I take up law on conciliation, I would be restricting myself to Industrial Disputes Act and Arbitration and Conciliation Act. These two legislations had made a mention of conciliation as a method of resolution of dispute, but later on there are many other legislations which included conciliations. I would be making passing reference to those things. I may not discuss those acts in detail. When I come to arbitration for discussion, I would be taking up definition as usual, followed by the process of arbitration and very important aspects as to what could be arbitrated, what cannot be arbitrated, what are the remedies available with arbitration process in case you are not happy with the outcome of arbitration. So, this is how the briefly I would be dealing with the discussion on scheme of the study. So, let us start with today's discussion. Before that, let me introduce myself. Dr. B.S. Patil. I am working as assistant professor at V.M. Salgaonkar College of Law, Goa, and I would be making a presentation, as you all know, and this is my second presentation on the same theme. So, when we talk about conciliation, what is this conciliation? For your information, conciliation and mediation looks to be very similar, and the role of the conciliator and mediator also seems to be identical. In this situation, how do you differentiate between conciliation and mediation? So, there has been various attempts have been made to discuss. The problem is there is no consistency shown by the legislatures. Sometimes legislatures use it interchangeably, sometimes they use it separately, sometimes they treat it as entirely two different authorities. So, just briefly we will understand what is conciliation is all about. Now, conciliation, like mediation, is a persuading authority and is going to pursue the parties to come to an amicable settlement of the dispute. He is majority time a non-adjudicatory authority, and he would not be adjudicating on anything, and definitely is a non-adversarial process where parties are treated as friends of each other rather than adversaries. So, in this whole process there is a third party who is known as a conciliator, and this third party has to be impartial, independent, and he would be discharging the role which is called as enabling role, and he would be empowering the parties to come up with an effective, efficient and smart agreement between them, and whatever outcome would be satisfactory to both the parties and which is acceptable to both the parties. So, these are the basic duties of the conciliator, that is enable the parties to come to satisfactory and acceptable settlement of the dispute. Conciliation basically works with mutual determination. Now, mutual determination means it is not somebody else deciding for the parties, but it is parties who are deciding by themselves, and when parties decide by themselves, they are coming up with mutual agreement on the disputed area, and it is a consensual nature. Again, it is not forced upon the parties voluntarily agree for it, and if parties are not happy with it, then the parties are allowed to walk out of this whole process. And it is actually a friendly search for an amicable solution. That is what conciliation is about, a friendly search for an amicable solution. The most important characteristic of this conciliation process is absence of procedural constraints. When you go to court, when you go to other authorities, they are bound by the procedures. Until those procedures are fulfilled, they are not permitted to proceed further, and all those procedural restraints are absent. And more importantly, and I am very happy that there are no formal technicalities involved in this. Therefore, no order, no discussion and no agreement would be set aside for not following those formalities. In addition to enabling parties, here is a man called a conciliator who is going to visualize the options, who is going to encourage parties to come up with the options, he is going to encourage parties to come up with a settlement of the agreement based on those multiple options. And what is considered in this whole process is the interest and the priorities of the parties. It is not the rights and liabilities, but it is the interest which is the driving force behind the whole conciliation process. So, therefore, when we talk about conciliation, we are talking about a process where the interest of the parties are protected, and it is protected by themselves, not by anybody else. So, this is what the conciliation is all about. I hope you have got a fair idea about what is conciliation. It is somewhat similar to negotiation, it is similar to mediation, and I stand by the statement that it is an improved version of negotiation, because there is a third party who is taking care of it. So, when I am talking about conciliation, you might be feeling that I am introducing a new concept to the Indian legal system, but I am afraid you are wrong. It is not a new concept for Indian legal system. It was existing in ancient time, because the Kautilya in Maurya dynasty time had proposed this conciliation, and it was utilized to a very large extent during that time. Himachal Pradesh High Court used this concept, that is conciliation courts, for resolving most of the rent disputes in 1980s, and they were very successful with this. With the success story of Himachal Pradesh High Court, the Law Commission of India made a series of recommendations for introducing conciliation in the Indian legal system. 77th and 129th report of Law Commission suggested that we should go for conciliation as one of the important mode for settlement of disputes. In addition to the Law Commission, Malimat Committee also recommended conciliation. They went ahead a step and stated that conciliation could be part of criminal justice system also, where they tried to introduce plea bargaining concept, and they were successful in introducing it. So, from where all these ideas came, that is suggesting conciliation courts, that is by Himachal Pradesh High Courts, suggestion from Law Commission, suggestion from Malimat Committee. It is not that it has come from vacuum. There is a lot of work going on in international community on this. So, United Nations has established an organ in Hague, that is United Nations Commission on International Trade Law. This United Nations Commission on International Trade Law is popularly known as UNCITRAL. This UNCITRAL organ of United Nations introduced model law for ADRS. In 1980, they introduced a model law for conciliation, where they said that all the states should come up with the conciliation law in their local municipal legal system on the line of the model suggested by the UNCITRAL. Similarly, in the 1985, arbitration model law was proposed by UNCITRAL law, and the Indian legislatures picked up these two concepts of 1980 and 1985, introduced into our Indian legal system, and they called it as Arbitration and Conciliation Act 1996. So, this is an important development in the international community. We the world as a citizen of India. Now we are thinking of becoming citizen of the world. Globalization came up with a concept called global village, and if you want to convert the whole globe into one village, we need to have one legal system, and this is one step towards having a common legal system. But anyway, it is concerned with commercial law. So, if a business community wants to move from one state to another state, they need not worry about the foreign legal system, because they are going to have similar or sometimes identical arbitration laws, identical conciliation laws. In case of dispute, the matter could be resolved, because there is no surprise pack in this whole process, because we have a common legal system as far as arbitration is concerned. So, therefore, it is one concrete step towards concept of global village. So, coming to Indian legal system, the law on conciliation, there are various legislations which suggest it, and success rate of these conciliation concepts in different legislations differs. Family Courts Act suggested conciliation. Industrial Disputes Act in 1947 also suggested conciliation along with other authorities to resolve the dispute. Now, if you look at these two legislations, there is one common feature in these two legislations, that is early resolution of dispute is one of the basic requirement of both the laws. Industry needs to function peacefully without any disputes. So, therefore, there is a need for resolution of dispute at the earliest point. Families needs to exist without any disputes. So, therefore, there again we need an early resolution of dispute, and most importantly, the resolution of dispute should be through an amicable conciliatory process. The other legislations like Civil Procedure Code also proposed conciliation, that is section 89 of CPC. Arbitration Conciliation Act, that is what I had mentioned in the earlier slide, that it is an influence of international community, which we also passed the legislation in 1996, and they are the major backbone for arbitration and conciliation in India. And the latest addition is Consumer Protection Act, which also established the Conciliation Council, which is going to deal with the disputes in a conciliatory manner. And in my presentation, instead of taking all the legislations, I would be taking discussion on Arbitration Conciliation Act and Industrial Disputes Act. Let me start with Industrial Disputes Act. If you go through the legislation, they do not bother to define what is conciliation. That is again a major indication that conciliation is not a new concept. Legislatures felt that there is no need to define conciliation, as it has already been understood by all the legal stakeholders in India. But when you go into section 4, where they define what is the role of conciliation officer, they use the following language. They say conciliation officer is charged with duty of mediating in and promoting the settlement of industrial disputes. So, here what conciliator is supposed to do is mediate between the parties. See, the legislatures have asked conciliator to mediate, means they are the words which could be used interchangeably. So, that is what I was trying to tell you, that international community already have moved ahead and they tried not to take up this discussion, the distinction between conciliation and mediation. They already accepted it as interchangeably used. Indian community or Indian legal system, still we are calling with two different names, and there is inconsistency in approach. So, I will leave this discussion at this stage, because I have to cover the more basic things in this. So, therefore, is conciliation and mediation one and the same? Is the role of mediator and conciliator is one and the same? The answer is may not be identical, but it is mostly similar. Some technical distinctions have been made by some of the authors, but they are again not to be taken into too seriously. So, when we establish a conciliation officer under Industrial Disputes Act, the Act suggests various powers and functions for the conciliator. So, again I will draw your attention to earlier slides. We were talking about the role of conciliator, and everywhere it is written he is only an enabling authority. He is only an authority who is going to suggest. It is the parties who should agree. It is the friendly manner of bringing out an amicable settlement. So, in these situations, when conciliator is not a deciding authority who cannot enforce any of his views, what is the use of these powers? Are these powers are going to be the major hindrance in achieving settlement agreement? Let us look into those powers first. So, conciliation officer being a facilitator, mediator, and he is a promoter of settlement, he is given certain powers when actually parties are in the driving seat. Conciliator is not at the driver's seat, but it is the parties. One of the important power which conciliator enjoys is power to enter any premises and conduct investigation. So, when he enters the premises, conducts the investigation, comes up with the facts, comes up with evidences. What are the use of these facts and evidences? He is not going to decide anything. Second important power is to conduct inspection. He can conduct inspection of the premises, documents, etc. What is the use of all these powers when section 21 of Industrial Disputes Act clearly prohibits from using those information which is collected during conciliation in any other proceedings. So, whatever information is collecting has to be kept with himself. Whatever information is collected cannot be used in conciliation, and it cannot be given to any other authorities for their use. So, therefore, these powers have been given without much thought. The other powers is power to enforce attendance of a person. Now, here interesting thing is they use the term person. So, when you use the term person, we are excluding one important aspect, that parties are not included within this enforcement of attendance. When we say person, we are talking about the persons who could appear as witnesses, and they could be called for two purposes. Purpose number one, to appear and depose before the parties about certain important information. Purpose 2 would be appear, produce certain documents which is there in their custody. So, in these two purposes, I find this is an interesting and important power, because clarity as to facts should be achieved before we proceed with the conciliation process. Then conciliation officer is a deemed public servant. He has all the protection of section 21 of Indian Penal Code, very well, most required, because he would be immune from all the proceedings connected with the conciliation. So, these are relevant powers which are enjoyed by the conciliation officers. Then coming to power to conduct the conciliation proceedings. So, whenever there is a dispute in an industry, conciliation officer is supposed to conduct conciliation proceedings. Is it mandatory or is it optional? The answer is it is optional in every industry, because it is a conciliation officer who decides that whether it is worth to be conciliated or whether the dispute is of such nature that it should go to adjudicatory authorities. But if the industry qualifies to be public utility service, a service which general society would be directly affected, there conducting of conciliation proceedings becomes mandatory. So, therefore, power to conduct conciliation proceedings is mandatory as well as optional, depending on the nature of industry where the dispute has occurred. Reporting of conciliation proceedings. Now, there is one important authority under Industrial Disputes Act called appropriate government. When the dispute arises, the appropriate government takes up the dispute and refers it to the relevant authorities. So, conciliation officer supposed to make a report and submit it to the appropriate government, so that it can take an appropriate action on the report. So, whenever a conciliation officer conducts a conciliation proceedings, he would come up with two possible outcomes: one successful conciliation, other one is a failure. When conciliation proceeding succeeds, then he is duty bound to draft a memorandum of settlement, gets signed by all the parties, countersigned by the conciliator, and submit the memoranda to the appropriate government. So, that is the end of the dispute, that is the end of the proceedings. Sometimes conciliation officer fails to come up with the settlement. In those circumstances, the conciliation officer is supposed to prepare an elaborate report about what kind of steps he took to resolve the dispute. Along with the steps, he also has to mention brief set of facts and circumstances which led to the dispute. And then comes most important part of the report. Along with these two informations, he has to give information as to full statement as to the reasons why they could not come to a settlement. When you say why they could not come to a settlement, means there would be a blame on one of the party who had not agreed with the settlement, who has not agreed with the proposals, who has not agreed with the options. In these situations, it becomes very difficult for a conciliation officer as well as the parties for the conciliation to proceed with other authorities. As I mentioned in the earlier slide, that section 21 of Industrial Disputes Act prohibits conciliation officer from sending the information to any other authorities. Here is a rule, here is a section which makes it mandatory that the conciliation officer must reveal the details of the conciliation proceedings, why it failed, who was the cause for the failure. I find that this information that is required under this section should not be allowed, because it goes against the basic tenets of conciliation proceedings. So, once the report is given to the appropriate government, the appropriate government takes suitable action. So, why the failure report should contain those informations? Now, here is one justification. I will leave it to you to decide whether it is a good law or bad law. The reason for submission of all the details is that appropriate government is going to decide what to do next. The next step of the appropriate government depends upon the report, because there are 4 kinds of authorities under Industrial Disputes Act. Like conciliation officer, there is another persuasive authority who is only pursue the parties to come to settlement. He is an enabling authority. There is inquisitorial authority who conducts investigation, cause for the problem, other details could be covered by that. There is a coercive authority like arbitration, like labor court, industrial tribunal, who force the parties to be abide by the award pronounced by them. Then there are preventive authorities who come into action before conciliation officer, because they try to prevent the dispute. So, looking into these different authorities, the appropriate government needs to check the nature of dispute, who is more suitable to resolve the case should be assessed. As there is one more persuasive authority available after conciliation officer, it is necessary for the court to know whether there is a chance of settlement and whether that additional authority could be utilized. That is the reason they ask for all the details of conciliation proceedings. They are not using it to decide the case, they are using it only enabling them to decide on further future steps. I am mentioning about the another persuasive authority, that is Board of Conciliation. The role is similar, there is not much difference. but here it would be going on at a higher degree with a higher professional approach. So, if the appropriate government thinks that the conciliation proceedings should be continued, but at a higher level, then the matter would be referred to Board of Conciliation, who is the second conciliatory authority under Industrial Disputes Act. Now, here there is a slight difference in the procedure. Instead of one single conciliation officer, there is going to be the conciliation officers referred by both the parties, one each. Then there would be one independent impartial person who act as a chairman of the board, and this would form a conciliation tribunal or what is called as Board of Conciliation, and this board is going to conduct a conciliation proceedings and try to come up with the amicable and acceptable settlement of the dispute. So, this is how the process is carried out under Industrial Disputes Act, where we have two officers, conciliation officer and Board of Conciliation, and the proceedings are almost similar. Now, let me move on to the next, Arbitration and Conciliation Act 1996. So, Arbitration and Conciliation Act is a product of UNCITRAL model law. Arbitration Conciliation Act is similar to other legislations in other legal systems. You take any other legal system in the world, and when it was passed to bring uniformity among the world, India had to repeal all the existing arbitration and conciliation laws. So, Arbitration Conciliation Act comes in three parts. Part 1 talks about arbitrations in India, where it repealed Arbitration Act 1940. Part 2 repealed two legislations which were a result of two conventions of the United Nations and one convention of League of Nations, that is Arbitration Protocol and Convention Act 1937, and second one is Foreign Awards Recognition and Enforcement Act 1960. Both these legislations were repealed by Arbitration and Conciliation Act 1996. Then there is part 3. This part 3, where I am going to discuss about, is about conciliation. So, the legislation has kept a separate part to deal with conciliation. So, under the 1996 legislation, conciliation scope is unlimited, anything, everything could be referred for conciliation. If you go by the language used in the section, it says all disputes relating to any legal relationship, whether contractual or not, should be referred to, could be referred to conciliation. So, we are talking about all disputes, we are talking about arising in a legal relationship, and we are ignoring important thing, that is whether it is a contractual or not. So, when you talk about legal relationship, the most of the relationship that exist in the society are all legal relationship, but they do not arise out of contract. Like your relationship with your neighbor, there is no contract between you, but you have certain you have duty to protect their rights and liabilities. But this blanket permission has got certain restrictions, where it says that certain kinds of disputes which cannot be conciliated because of the legislation, prohibition by the law. So, those things are not allowed. So, therefore, blanket permission comes up with a small restriction on it. So, once a dispute comes between the parties, they are going to, if they want to start a conciliation, how they are going to commence the conciliation. The commencement of conciliation is done through written communication. The party writes to other party, a party writes to conciliator, and parties agree for conciliation, and the conciliator agree to act as conciliator between the parties. So, that begins the conciliation. And this is the major I should say deviation from arbitration, where it requires existence of written arbitration agreement, but here such things are not required. So, what is required here is written invitation and acceptance of the invitation. So, when you write invitation requesting the parties to come for conciliation, the invitation must contain brief discussion on subject matter, major issues involved. So, therefore, they can come prepared what kind of steps they could take up. So, this is how the commencement of conciliation can take place, and during commencement process only there is appointment of appointment of conciliator. How many can act as a conciliator? Normally one person should be okay to run the conciliation show, because he being trusted by both the parties, he being having a faith of both the parties, he himself being independent and impartial, can control the conciliation proceedings very well. But the law provides that ordinarily one conciliator, but there can be two or more conciliators, and here there is no restriction that there should be only odd number of conciliators or uneven number of conciliators. So, there can be even number of conciliators who can function in a conciliation process. The simple reason is that the conciliation officer is not going to decide anything. So, when he is not an adjudicator authority, there is no risk of split decision. Odd number is maintained, uneven number is maintained, because in case of split decision, that decision becomes unenforceable. To avoid that, to ensure majority, we always have uneven number of adjudicatory authorities forming a tribunal. But here such risks do not exist. So, they do not insist on uneven number of conciliators. Now, this is, I find, kind of inspiration that is taken from Industrial Disputes Act, because when we go for board of conciliation, we go for a higher level of conciliation, there we have multiple conciliators sitting as conciliation board. So, now how do the procedure happens? First, conciliation officer being a stranger to the whole dispute, he would be having absolutely no idea about the dispute. So, therefore, first initial procedure is to appraise the conciliation officer with all the information relating to the dispute. For that purpose, the document should be sent by the parties to the conciliation officer. Now, here one precaution which must be followed by the parties is, all the communication that is made to the conciliator, same copy should be sent to other party also. Similarly, the other party which sends the communication to the conciliation officer, same thing is sent to this party. So, there is a complete communication between all the parties as well as the conciliation officer. After going through the documents, if the conciliation officer feels that he needs more information, then he can call for additional information as well. So, the role of the conciliator is assisting parties, developing positive dialogues between the parties, clarity as to the nature of dispute, clarity as to the interest of the parties, and clarifying the misunderstanding between the parties. So, this is going to be the major role of conciliation officer. And guiding principles, how conciliation officer should function. The most important thing is, he is not governed by CPC or Indian Evidence Act. So, therefore, there are no technicalities involved, there are no formalities involved, but there are certain principles he must not ignore. So, when he is dealing with parties, he must give due consideration to their past records, past dealings, previous practices, those things should be taken into consideration, plus circumstances around the dispute as well as the usage in the trade. If it is a business dispute, how the trade community deal with the dispute, what is the usage, what is the custom in the community, these things should be taken into consideration. In addition to that, other three things that should be considered is principles of objectivity, fairness of justice, and rights and obligations of the parties. This is how the conciliation would be worked out. and all the decisions relating to conciliation is always taken by the parties, and if parties fail to come to consensus, then it is the conciliation officer who takes all the decisions by consulting parties. So, he do not act as an authority over them, but he acts as an assistive partner to them. So, one important aspect of conciliation is private and joint sittings. When conciliation officer feels that he needs a private sitting with only one party, private sitting is meeting only one party in absence of the other party. With this, what happens? He build a good rapport with the other party and he can resolve the dispute without much delay. Similarly, he can sit with other private sitting with other party. Therefore, when we talk about joint and private sitting, it is a prerogative of the conciliation officer. Even parties can request that they want to have this private sittings, and these sittings are done to speed up the conciliation process. So, once the whole process is followed, then we come to the final leg, that is settlement agreement, most important part of the whole conciliation process. So, it is important not only because we are coming to an end to the dispute, it is also important because you should ensure that it will not lead to further dispute. So, drafting of settlement agreement happens to be the most important aspect of the whole conciliation process. So, first it has to be drafted, then it should be authenticated by the signature of the parties, conciliation officer. It is a duty of the conciliation officer that he should give full understanding of the terms of the agreement by explaining to the parties. There can be even partial settlement of the dispute, because certain areas they want it to be decided by the authorities, adjudicator authorities. It is the will of the parties. So, they can only come up with a partial settlement, remaining could be referred to adjudicator authorities, including arbitrators. So, once a settlement is drawn, settlement agreement is drafted, then it would be an arbitral award of on agreed terms. So, it has got a status of an award and it has got quite an enforceability in the eyes of the court. So, once the conciliation is successful, automatically the proceedings terminates, but sometimes when the conciliation is unsuccessful, there are different procedures in which you can terminate the proceedings, like party can give a written communication, say that they do not want to participate in conciliations anymore, that is the end of conciliation. Instead of parties, conciliation officer himself can mention that he is not willing to continue as there is no chance of settlement. So, that also brings an end to the conciliation proceedings. So, this is the brief discussion on conciliation. Let me browse through arbitration as quickly as possible. Again, it is a wrong notion, it is a myth that arbitration is a new concept. It was a part of Indian legal system from long time. Railways had arbitration clause in its law from 1777 itself. So, it is a very long time that it has been part of Indian legal system. So, therefore, you do not find definition of arbitration in any legislations. So, I have made a simple attempt to define what is arbitration. So, just try to distinguish between mediation, conciliation and arbitration when you listen to the definition. It is resolution of a dispute by a private judge. So, he is not a person, but a judge, and he is not a judge of a judiciary, but a private judge. He decides the dispute by passing a judgment called award. So, he is not encouraging parties to settle it, but he is deciding what party is supposed to do. And third important aspect is the decision of this private judge is binding on both the parties. So, this is how the arbitration functions. What can be arbitrated? Again, all commercial matters can be arbitrated, but there is a list which cannot be arbitrated, like matrimonial matters. Divorce cannot be arbitrated. Criminal issues, so you can't run away with the punishment by paying some compensation. Insolvency matters, anti-computation discussions, disputes, these things cannot be arbitrated, it has to be decided by the court. So, how the arbitration begins? The first step of arbitration is arbitration agreement. So, arbitration agreement, while drafting, parties can refer all or certain disputes to arbitration. They can also refer the dispute which is existing or dispute which may arise in future. That is why they use the term which have arisen or which may arise. So, all, certain, existing, future, everything could be referred to arbitration. So, this is the complete discretion of the parties. The dispute should be related to legal relationship, whether contractual or not. It is the same language what you heard under conciliation. The agreement should be in writing, it is mandatory. There were many questions raised that if not in writing, what happens? If not in writing, it is unenforceable, definitely not illegal. Unenforceable means you have to convert it into enforceable agreement and then follow it. So, therefore, oral arbitration agreement is not illegal, but it is only irregular. Again, to encourage arbitration, the legislature said that there need not be any arbitration agreement proper. Even if there is a suggestion made in one letter, acceptance is made in another letter, those two communications can be an arbitration agreement. They go one step further and they say that one person suggests arbitration, other person does not deny, arbitration agreement can come into existence. So, this is all, the idea is to encourage parties to go for arbitration, because the direct benefit falls on the court, because the court's burden gets reduced. If parties move towards arbitration, the burden on the court would come down. Once you have an arbitration agreement, it is going to have a quite compelling impact on the rights of the parties. First right which is taken away is your right to approach court. So, in spite of arbitration agreement, if the party goes to court, file a plaint, the plaint would be refused or it would be returned, and with the instruction that they should go before arbitrator. So, it is based upon a principle that a right created bilaterally, a right which is created by two parties, that is bilaterally, cannot be abrogated unilaterally. One party cannot cancel it, it has to be cancelled by both the parties. So, arbitration is a contractual right, you cannot cancel it alone, it has to be agreement between the parties to cancel arbitration. So, therefore, if a plaint is filed, the defendant can appear before a court and request the parties to send back to arbitration. Can a judicial authority refer them to arbitration on its own? The answer is no, it is only if the other party requests. If other party does not request, then it means that they have bilaterally rejected arbitration agreement. So, therefore, request from defendant is mandatory. Second consequence of this effect of arbitration agreement is interim measures from court. Before referring it to arbitration, before going through arbitration process, the parties can protect the subject matter of dispute by getting interim measures from the court. That is the great help that is provided under the Act. So, after arbitration agreement, after arisal of dispute, now we need to constitute a tribunal. How many can form a tribunal? It can be 1, it can be 3, but it cannot be 2. So, therefore, number is left to the parties to fix. The number should be uneven number, it cannot be even number. So, here the problem is split decision. So, when a private judge pronounces decision, if there are two different contradictory observations, it becomes unenforceable. So, therefore, they have to have odd number of judges, that is arbitrators. How the appointment is made? Is the parties who make an appointment. First, they have to fix the number, single arbitrator or 3 arbitrators or 5 arbitrators. The number should be odd. how many not restricted. So, generally I will, for the sake of discussion, I will take 1 and 3 as the number. So, if there is a single arbitrator, the appointment would be done by the consensus of both the parties. If the parties cannot agree on one single name, then it has to be referred to Chief Justice, and the Chief Justice would make an appointment on behalf of parties. Simple process, and there is no cause for delay. So, when you can make an application to the Chief Justice? So, 30 days time is given to the parties to decide on the name of the arbitrator. If they cannot decide within 30 days, make an application to Chief Justice. Chief Justice will appoint on behalf of parties. But when it comes to 3 arbitrators, there is a slight change in the process. First, they try to agree on 3 names. If not possible, then both parties will refer one name each, and both arbitrators would appoint one presiding arbitrator. So, if parties do not refer within 30 days, if the arbitrators do not recommend one name within 30 days, then same process, make an application to Chief Justice. Chief Justice will appoint on their behalf. So, when we talk about Chief Justice, who is this Chief Justice? Whether he is the Chief Justice of High Court or Chief Justice of a Supreme Court. He is Chief Justice of High Court as long as the arbitration is a domestic arbitration, where both parties are Indians. The subject matter is Indian, law involved is Indian. So, that becomes the Chief Justice of a High Court. But if the arbitration is international commercial arbitration, then the Chief Justice means Chief Justice of India, the Chief Justice of the Supreme Court. So, along with this appointment power, Chief Justice also enjoys the power to frame a scheme of appointment through which the appointment could be made. So, we constituted the arbitral tribunal. Then comes the question of jurisdiction. So, if there are 2 kinds of problems with jurisdiction. Jurisdiction, that is the tribunal functioning without jurisdiction, tribunal exceeding the jurisdiction. Exceeding jurisdiction means they start with a process within the jurisdiction, but during the process they exceed, they go beyond the scope of arbitration agreement. In both the cases, lack of jurisdiction, exceeding of jurisdiction is the arbitral tribunal who decides, and it is non-appealable. Once the court says, the tribunal says that they have a jurisdiction, and then they will proceed with the matter, parties cannot question the decision with the court. This is another important impact of arbitration agreement. So, they cannot approach the court. Conduct of arbitral proceedings. So, once the arbitral tribunal is constituted, the process starts. First they fix the place of arbitration, then they have a choice of language, both could be decided by the parties only, and if they fail to do it, then it can be referred to other tribunals, that is arbitral tribunals. Statement of claim and defense should be submitted by both the parties on the agreed procedure between them. Hearing and written proceedings, here there is a departure from CPC. The arbitral tribunal can decide to have only written proceedings, no oral hearings. Whatever you want to say, you submit it in writing, it would be conveyed, copied, and copy would be supplied to all the parties involved, and there would be no discussion, oral discussion on it, and there would be award on those written submissions. The arbitral tribunal can take the assistance of the experts, or even they can take the assistance of the court to gain the attendance of witness. Choice of law. Which law is going to govern the arbitration? So, when I say law, I am talking about procedural as well as substantive law. So, when procedural law comes, the same rule is applicable. CPC, Indian Evidence Act, not applicable. So, they are going to have their own procedure, they are going to have their own evidence law. But when it comes to substantive law, There are two kinds of arbitration. I mentioned it while discussing about Chief Justice. Domestic arbitration, when the parties are Indian, arbitration is in India, the dispute cause of action is in India, subject matter is in India, Indian law will govern it. So, here substantive law choice is not given to the parties, they are governed by the Indian law. But when the arbitration is international commercial arbitration, then the parties have a choice. They can choose any legal system and they could be governed by those legal system. That is the advantage of arbitration, that is choice of law. So, during this arbitration process, there is one important deviation from the process, that is settlement in arbitration. When I defined arbitration, I said the outcome of the arbitration is a judgment which is called as an award, but now I am talking about a settlement during arbitration. This is again an indication that conciliation, mediation and negotiation are the best way to resolve commercial disputes. So, even during arbitration, the arbitrators can encourage parties to go for conciliation and settle the dispute. So, that is under section 30 of Arbitration and Conciliation Act. So, when you talk about forms and contents of an award, the award has to be in writing, that is for sure. It should be signed by majority, but one important aspect to be discussed here is reasons for the award. Till 1996, we were unanimous with our opinion that the reasons need not be given for an award, but here the reasons is made compulsory. Why the decision is going in favor of party A, the reasons should be enlisted, but earlier it was not necessary. But with it is with two exceptions. Exception number one is if parties do not want reasons, they can authorize the arbitral tribunal, do not give reasons, just give us decision. And if there is a settlement during arbitration, then as it is not his decision, he would not be in a position to give any reasons for that. And there is an interim arbitral award, there is interest and cost on the award. So, interim arbitral award is an award where rights of the parties is decided, but the dispute does not come to an end, but it will continue with other aspects of the dispute. So, once the award is pronounced, automatically the arbitral tribunal's function comes to an end. So, that is once a final award is pronounced, that is the termination of proceedings. There are other ways also in which the proceedings can terminate. Withdrawal of claim. If the person who has submitted the claim withdraws, the tribunal function terminates. But here one condition is there, that the defendant should not object. If he objects, then the proceedings will continue. Parties can agree to terminate through writing, through an agreement they can terminate the proceedings. Then arbitral tribunal itself can terminate if they find that the cooperation of the parties or the nature of the dispute is such that they cannot continue with the proceedings. So, with this there is an end to arbitral proceedings. Now, we have award in our hand, but if parties are not happy with the award, what they can do? Because award is binding on them and they think that the award is not correct. What is the remedy? The remedy is they can go to court and ask for setting aside of the award. So, setting aside of the award is based upon 7 grounds. One is incapacity of the parties. So, if you go through those grounds, mostly they all look like the defects with procedures. So, the court do not interfere with the award, but they will interfere with the procedure. First ground is incapacity of the parties. If the parties do not have capacity to enter into an arbitration agreement, no capacity to participate in arbitration agreement or arbitral proceedings, then the award could be set aside. Incapacity, Indian Contract Act provides all the capacities, but there are other legislations also which play an important role. So, those capacities should be checked. Arbitration agreement is void, then award could be set aside. Lack of notice. So, appointment of arbitrator, notice of proceedings, lack of notice which provides difficulty for the parties to prepare a case and present the case, this could be the grounds for setting aside an award. If the award is beyond the scope of arbitration agreement, ultra vires award, the award is not within the terms of agreement, not contemplated by the parties, beyond the scope of the agreement, the award could be set aside. Composition of the arbitral tribunal, if it is not according to arbitration agreement, award would be set aside. If subject matter is not capable of arbitration, award could be set aside. And the last one, the most important one is, if the award is against public policy, then award could be set aside. Then there is a last resort. After arbitration, you go for setting aside. After setting aside, you go for appeal. Now, this is the last stage in the arbitration process. So, when you go to appeal, you can go in appeal on 4 grounds. Number 1, interim measures ordered by the court. You can go against it, you can go for refusing it, you can go to court in appeal. If the application for setting aside is made and the award is set aside, you can go in appeal and request the court to relook into the decision. And application is made and it is rejected, then also you can go for relook into the decision. There are certain decisions of the arbitral tribunal which could be appealed, like jurisdictional issues. If the arbitral tribunal decides that it has no jurisdiction, please remember, it has no jurisdiction, only that matter is appealable. If it says it has jurisdiction, it is non-appealable. Interim orders, interim measures taken by the arbitral tribunal, they are appealable. So, these are the provisions in which appeals could be made. So, this is my brief discussion on conciliation and arbitration. I request you to contact me through the forum which has been established under this whole process. I would be very happy to help you out in case of any queries. Thank you very much and all the best.